suing his ex-fiancée, daycare owner Karen Watkins, for the return of bedroom furniture, a refrigerator, and the engagement ring. Karen says Jean's lawsuit is ridiculous.
Yes, it's case number 208 on the calendar in the matter of Lorsch versus Watkins. Parties have been sworn in. Judge, you may be seated, sir. Have a seat, please.
Mr. Lorsch, you and the defendant were together for about 7 years, according to what I read in your complaint, and engaged for 3 or 4 of those years. You broke up, and you want returned to you some furniture, and you also want the engagement ring back. Ms. Watkins says the furniture's been in her house for years, never asked for it back. As a matter of fact, you don't even want the furniture back. You want the value of the furniture because you've already replaced it. And as far as the engagement ring is concerned, she said she hasn't seen it for years. So either you took it back or it was lost. And you lived together for 2 years after it was lost. Is that right?
Yes.
Okay. When did the two of you live together? During which period of time?
Well, I'd say from 99 to 2003.
And when you left, did you take anything with you?
No, Your Honor, I did not.
Your Honor, that's not true.
What did he take with him?
He took his couch. He took the bedroom set that was in my bedroom.
Did you take the couch? When you moved out, sir, did you take the sofa?
Your Honor, yes, I did.
I mean, I do speak the language, and I assume you do too, so I don't know why you're confused. Did you take a bed?
Just a bed and headboard itself, yes.
Okay. What else did he take, Miss Watkins?
Well, those are the main furniture things that we had there.
Okay, those are the furniture things. Now we're a year later, more than a year later, and you want a refrigerator, not the refrigerator, the cost of the refrigerator, and you want some bedroom furniture that you purchased because each of you had a daughter.
Correct.
And you bought some bedroom furniture so that the 2 girls could be in the same bedroom.
That's right, Your Honor. It made it more comfortable for my daughter to be in her place. Like I said, she provided daycare for me for the whole time that we were together, and I was paying her daycare fees.
Mr. Lorsch, listen to me. We're getting beyond ourselves, sir. I like to keep things very simple. When you moved out in June of 2003, did you ask her for the refrigerator?
Yes, I did, Your Honor.
That's not true.
Shh, just a second. Don't say anything that's not true, because I will make you look very foolish.
This was something...
Just a second. Don't say anything that's not true, or I will make you look very foolish. And you don't want that. So, I'm going to start all over again. Did you ask her for the refrigerator in June of 2003?
Yes, Your Honor, I did.
Okay. And did you ask her for the children's furniture in June of 2003?
At that point in time, no, Your Honor, I did not.
But you did ask her for the refrigerator?
Yes, I did.
And what did she say?
She thought that I owed it to her.
And what did you say?
I said, I think, your new boyfriend can get you a new refrigerator.
Okay. And what did she say?
She said, I think that rightfully belongs to me now.
Okay. And that's the way it was left?
Yes.
You did not sue her for that, right?
Not at that point in time, no, I did not.
Over a year ago. Nor did you sue her for the children's furniture, correct?
I did ask her for the stuff on occasion.
Listen to my words very carefully. You did not sue her for those items in June of 2003.
It was a continuing discussion over the year.
When was it a continuing discussion, Mr. Lorsch? Was it a continuing discussion each time you would take your daughter there for her to provide daycare?
More like on a monthly basis.
And you had this conversation with her on a monthly basis while she was taking care of your child. Is that what you're telling me?
That's correct.
Okay. Now, when your daughter was not with Miss Watkins, was she back in your home with you or your former wife?
My former wife, yes.
Did she ever come to stay in your home?
Yes.
For a day, or 2 days, or 3 days?
3 or 4 days usually.
Yeah.
Oh, shh. And when she came to your home, did you feed her?
In the evenings, yes.
And when you fed her, did you use a refrigerator?
Yes, I did.
Where'd you get it from?
I had to purchase a new one to replace the old.
When did you purchase the new one?
I have that in here.
Well, why don't you tell me about it?
May 7th of this year.
So is what you're telling me, Mr. Lorsch, between June of 2003 and May of 2004, you lived without a refrigerator?
No, I had a portable unit.
So you had a refrigerator.
A small one, yes.
Good for you. Now, when did you purchase new bedroom furniture for your daughter to sleep in?
Actually, I do not have it yet.
You don't? So where was your daughter sleeping? She wasn't sleeping with you.
She is either sleeping on the couch or she'll sleep in a sleeping bag in her room.
In a sleeping bag in her room.
This is on call. They're supposed to call me when it's delivered.
Is what you're telling me the way that you provided for your daughter when she was with you is to have her sleep on the floor? Is that what you're telling me?
No, Your Honor. At the time, I had a day bed.
There we go. That's better. In what year did you purchase the bedroom furniture that was in Miss Watkins' home?
That was November 30th of '02, like 6 months before she decided she didn't want to be with me anymore. It's awfully convenient.
No, there were a lot of nights, sir, between November of '02 and June of '03.
Yeah.
It's only 6 months, Your Honor.
That's a lot of nights. Now, where's the engagement ring?
It's gone. I took it off because I wasn't ready to be married. I took it off. The next day where I put it, I went to get it. It was gone.
When was this?
I think he took it.
When?
Oh, gosh. Approximately two years ago, maybe possibly 3.
Did you discuss the fact with Mr. Lorsch that you didn't have the ring?
Yeah, I went to get it, and I said, I took the ring off, and it was gone. I still think he took it because he's so controlling, and he probably took it until the time that he, because we were still dating, and so he probably...
Listen, when you live together, and you share a room, and you share a life, and you have children over, that's not dating. Dating is what you do when somebody comes to your house, picks you up on a Friday night, takes you to dinner and to a movie, and then brings you home. That's dating.
Judge Judy continues in a moment. Lorsch says ex-fiancée Karen Watkins owes for the return of a bedroom set, a refrigerator, and an engagement ring.
Now, Mr. Lorsch, while you were living together, do you recall a time that she no longer had the engagement ring?
When she said that she, didn't want to date anymore.
No, look at me. Don't look down at your papers. My question to you is...
I asked her at that time.
Just a second. Mr. Lorsch, do you see how foolish I made you look 5 minutes ago? If you don't see it, everybody else has seen it. Now, I'm going to ask you again. I'm going to give you another chance, sir. Did there come a time while you were living together with Miss Watkins that she was no longer wearing the engagement ring?
At the point she called it off, yes.
Good.
I asked her about it then, and she said she stopped wearing it 2 months prior, which was just last year.
So there was a time, listen to me. So there was a time while you were living together that she was not wearing the engagement ring. Is that right?
According to her, yes.
No, according to you. I said there was a time while you were living together that she was not wearing the engagement ring.
It seems apparent, yes.
It was apparent. Now, when you saw that she was not wearing the engagement ring, did you continue to share a room with her?
No, Your Honor.
I want to listen. You're trying to think of how to answer these questions so that this decision will go in your favor. And I'm telling you only one thing, sir. I am a master at ferreting out the truth. So as smart as you think you are, you're not smarter than I am. We understand each other, Mr. Lorsch?
Yes, Your
My
Honor.
question to you is a simple one, sir. Now that you have acknowledged that while you were living together, she stopped wearing the ring for whatever reason, what kind of discussion did you have with her about the ring?
If she was calling the engagement, I asked her if I could have it back. She says, I have misplaced it, and when I find it, I will return it to you.
After she said she misplaced it, did you ever see it again?
No, Your Honor, I did not.
Now, after you broke up in June of 2003, it had been, let us say, months that she hadn't worn the ring. Did you say to her, did you find the ring?
Yes.
And what did she say to you?
Haven't had a chance to look for it yet.
Yeah, that's not entirely true. He never asked for the ring. Is what he would do is threaten me and point at me and say, if you don't find the ring, I'm going to take you to court and I'm going to ruin you in court. And that's what he used to always do to me, is point at me and corner me and threaten me,
So he asked you for the ring, he demanded the ring back. Now, we're not talking about the Hope Diamond here. We're talking about a ring that, according to you, Mr. Lorsch, you spent $700 on. Is that right?
That's correct.
Get over it. Mr. Lorsch, if you lie about one thing, I doubt the veracity of everything that you say. Do we
Your Honor,
understand each other?
she lies in
Do we
court,
understand? Do we understand each other? It's not her burden, sir. It's your burden. So when you come to court, it's your burden of proof to go forward and convince me that you have just cause. And what you've said in your complaint is, I don't want the refrigerator back, and I don't want the bedroom furniture back. I wanted to pay me the replacement value of it, because I went out and I bought a new refrigerator a year later, and I went out and bought new furniture that I haven't gotten yet. Get a
Your
life.
Honor.
Mr. Lorsch, you're out of here. Goodbye. Case is dismissed.
Parties are excused. You may step out.
And now the next case.
All parties in the matter of Sisson versus Chapman. Step forward, please.
Assembly worker Linda Sisson is suing her son's ex-girlfriend, 21-year-old banquet server Tessa Chapman, for the cost to fix her Chevy Cavalier. Tessa says the only reason she drove the vehicle was because Linda's son was drunk.
Ms. Sisson, the defendant is your son's former girlfriend.
Yes.
And according to your complaint, she drove your car and had an accident.
Yes.
You want her to pay for the damage.
Yes.
When did the accident take place?
April 3rd, 2004 at 1 a.m.
You weren't there, is that right?
We were sleeping.
So you didn't see what happened?
No, I did not.
Okay, Ms. Chapman, and you say you're not responsible. Let me hear about it.
George Anderson and I were hanging out at his mother, Linda Sisson's house.
George Anderson is your son?
Yes.
A few hours later, George had asked me to drive to the store with him. While we were driving to the store, I realized he was intoxicated.
That is not true.
Shh, listen to me. I don't want you to say anything. You weren't there. I've asked her a question. Got it?
Yes, Your
Good.
Honor.
So you and the plaintiff's son were hanging around at her home.
Right.
When had you arrived there?
Probably at like 10 o'clock around.
10 in the morning or 10 at night?
10 at night.
And where had you been before that?
My house.
So you drove over to his house?
No, he came and picked me up.
In whose car?
His mother's car.
When he came to pick you up and you got into the car, was he intoxicated?
No.
How long did it take you to get back to his house?
About 10 minutes.
And you went directly to his house?
Yes.
At what time did you go to the store?
Like 12:30.
Between 10 p.m. or 10:10 p.m. when you arrived back at George's house and 12:30 in the morning, what were you doing?
We were watching TV and we had a couple beers each.
Where did you get the beers from?
His house.
So each of you had a couple of beers. Is that right?
Yes.
And then about 12:30, who decided to go to the store?
George.
You say in your answer that the reason you were driving was because George was drunk.
Yes.
Not according to what you tell me now. According to what you tell me now, the two of you had a couple of beers.
He must have been.
He what?
There was another girl there named Stacy, and they were off in another room for a little while also, so they could have been drinking without
They
me knowing.
could have been, and I could have been 5'6", but I'm not. So when he asked you to go to the store, and you said yes, you knew that you had been drinking,
Yeah.
and you knew that he had been drinking.
Yep.
At what point did you drive?
On the way home, back to her house.
Miss Sesson, I don't want you to say no unless you were there. Do you understand?
Yes, ma'am.
And you weren't. Right?
Yes, ma'am.
Now tell me about the accident.
We were driving back. The ride was fine on the way back, and we got back to the house, and I went to pull into the driveway. And in their driveway, there's a little metal pipe that sticks up, and you can't really run it over, so I was backing out to straighten up the car to pull into the driveway. And the cars on the road were parked very close to the driveway, and I accidentally scraped the other car.
Now what makes you think you're not responsible?
Because I feel as though she's suing me because I broke up with her son.
That's possible. That she decided to sue you now because you broke up with her son. There was no longer a reason for her not to pursue this remedy. My question to you is, why don't you think you're responsible? That's her motive for suing you.
Because George was drunk and I wasn't drunk on the way back from the store, driving back.
Well, Miss Chapman, you had certainly, according to you, been drinking that night.
Yeah, but 2 beers in a course of 2 hours, 2.5 hours.
And that's all you told me you saw George drink.
But he was driving very recklessly on the way to the store.
Then you can get out of the car, right?
Mm-hmm.
Who is this?
That's my mother.
Do you live at home with your mother?
No, I live at my own house.
Do you get along with your mother?
Yes, but she
Does
lives...
she live in the same town that
Nope.
you do? Do you have other people that you know in town?
Mm-hmm.
So that if he was driving, according to you, recklessly on his way to the store, then you say, George, I'm not going to get back into the car with you. And you call a taxi to take you home. But if you get behind the wheel of her car and you have an accident and you've had alcohol that night, you're responsible. And the fact that she may not have pursued this matter while you were with her son, and now you're no longer with him because where is he? Drug rehab? He's in jail? Where is he?
He's in rehab, getting treatment.
Good, I'm glad. How much was the damage to your car?
It was $1,300, which I had to pay a $500 deductible. And when I found out about the accident, the doorbell rang at 7 o'clock in the morning. And
I don't care how you found out about the accident.
Well, she admitted to me, Tessa admitted to me that morning when I woke them up to find out what happened to my car, and she apologized because my son came out and told Tessa to tell me that he's not taking the rap because he didn't do the damages, and she did
No, he's a prince.
And she did the
He's
damages.
a prince. How old is your son?
22.
How long has he had a drug problem?
Maybe about three weeks prior.
You're in denial, madam. What kind of work was he doing?
He was in and out of jobs.
Had he been arrested previous to his current rehab?
Yes.
For what?
For a stolen vehicle.
Yes. What else?
False identification.
What else?
Counterfeit money.
She doesn't get a free ride. She should not have gotten in the car with him. She should not have been driving that night. She is responsible for your out-of-pocket expenses. And if I had a kid who was in this much trouble, I would have taken my car keys and locked them up in a safe to make sure that he didn't use them. Right?
Yes.
Good. So, you got to pay her deductible, Miss Chapman. It's your responsibility. Judgment for the plaintiff in the amount of $500. That's all.
Parties are excused. You may step out.
James Frederick is suing his girlfriend's ex, security officer David Abbasi, for breaking his ankle during a fight. David says James attacked him.
Now, this is case number 80 on the calendar in the matter of Frederick versus Abbasi. Parties have been sworn in. Judge, you may be seated. Folks, have seats, please.
Mr. Frederick, the defendant is your girlfriend's ex-boyfriend, and it is your claim that you both found yourself at the same bar and that Mr. Abbasi assaulted you at the bar, causing you to fracture your ankle. You want him to pay all of your expenses relative to that assault and also some punitive damages. Mr. Abbasi says that you were the aggressor that night. He didn't see you injure yourself, and if it wasn't for your aggressive behavior, none of this would have happened. That's your defense. Is that right?
Yes.
When did this incident occur?
The night of February 7th, approximately 10:30.
And what was the name of the establishment that you were visiting?
The Horseshoe Pub.
What time did you arrive there?
Approximately 10 o'clock, I believe.
When you got there, was the defendant there?
Yes, I did know who he was. I'd never met him before that time.
Had you been to this bar before?
Yes, not very much. I don't go out to bars very often.
What prompted you to go there this evening?
Just to get out for a little while. I was supposed to meet my girlfriend there a little later.
Well, did you meet her there?
Yes, she came in probably about an hour later.
Before she arrived, you didn't know who this gentleman was?
Right.
When your girlfriend arrived, she advised you who this was?
Yes, once she saw him.
And you didn't know who he was, sir, when he arrived there. Is that
No,
right?
I didn't.
How long has this young lady been your girlfriend? Or how long had she been your girlfriend on February 7th?
For 4 months, approximately.
How long had you been separated from her?
About 3 months.
You mean there was a month overlap?
Yeah, I believe they were 3 months in the relationship, not 4 months.
Did she leave you for him?
Yeah,
How long had you been together?
about a year and a half.
Were you upset?
Yeah,
Had you lived together?
yeah.
So she left you
She was cheating on me.
with him
Yeah,
and left the home that you shared to move in with you?
Yes. She wasn't cheating, Your Honor.
But she moved in with you immediately after she left him?
Correct, yes.
Okay. All right, so tell me what happened.
Well, on that night...
After your girlfriend arrived. We're at the point where your girlfriend arrived at the bar.
Okay. After she arrived, I noticed, well, she had told me who Mr. Abbasi was. At that point then, I acknowledged him.
How did you acknowledge him?
Well, after my girlfriend had told me who he was.
How did you acknowledge him, is my question. Did you shake his hand? Did you go over and say, hello, I'd like to introduce myself? How did you acknowledge him?
No, nothing like that.
Just tell me how you acknowledged him.
I just looked at him. That was it.
Okay.
After that, I didn't say anything, didn't do anything. She wanted to leave, which I probably should have taken her.
That was very smart of her.
Yes, it was.
She said, he's here and I want to leave.
Yes.
And you said...
I wanted to stick or I wanted to stay.
Me?
I should have went with her, decision. Afterwards, probably, I'd say 15, 20 minutes afterwards, Mr. Abbasi just started to look my way, and at both Lucy and I, and adjacent to him was a lady, and he was more or less smiling, laughing, pointing at us, and I just wanted to know what was going on. So I more or less shrugged my hands up. And
How far were you from him when you did that?
Maybe 20 feet.
It's not far.
Not very far, right. After that, basically, he got up in anger. At that point, he started really prancing or almost running towards me on the other side of the bar. And I didn't know what he wanted. I didn't know if he wanted to fight. I didn't know if he wanted to talk. So I got up and I met him halfway through the bar. At that point, I lost him in the crowd. There were a lot of people there. And after that, he shoved me after he saw me, and I didn't know where he was. I fell back into the crowd, and I tried to regain my balance. And after I tried to regain my balance, he shoved me again. This time, I fell backwards in an awkward way and broke my ankle.
Now, your version of the events, Mr. Abbasi.
He waved me over to fight.
Show me how he did that.
By putting his hands over like that.
He went like that?
Yeah, calling me, saying he's going to kick my butt. We met simultaneously.
I don't want you to make things up as you're going along, Mr. Abbasi. Listen to me. Are you telling me from across the bar you heard him say something to you?
No.
Or are you just showing me this?
I heard him say he's going to kick my butt and wave me over. And then...
And what did you do?
We both simultaneously...
No. So he waved you over to come over because he wanted to fight with you.
Yeah.
And you being the intelligent, sober guy that you are...
I wasn't sober.
Oh, you weren't? Well, that accounts for something. So you were drunk.
Yeah.
So he waved you over, and you went over to fight with him.
Well, I was just thinking we're going to stick chests and try and talk it down, but then when I seen his fist come in, I had to push him.
Your Honor, that's a lie.
No, I don't want to hear you.
I'm sorry.
So continue. Let's keep going. So you got over there. He's waving you on, saying he's going to kick your butt. You go over there to butt chests with him because that's all you thought he was going to do. You saw him fist up his hand, and so you pushed him.
Yeah.
Okay. And that's how he hurt his ankle. If he hurt his ankle at all.
He claims that my shove threw him 10 feet across the room into a pool table, causing his ankle to break in 3 spots.
Judge Judy continues in a moment. James Frederick says he was attacked by his girlfriend's ex-boyfriend, David Abbasi. David says James instigated the fight.
Now I'll hear you. Step up. Who are you?
I'm the bartender that night.
Let me ask you this. What's your last name?
Banks.
Miss Banks, you know Mr. Abbasi and his girlfriend. Is that
Yes.
right? And how long have you seen Mr. Frederick in the
I
bar?
only have seen him that one night.
Where do you come from?
Palmdale.
And this bar is in Palmdale?
Yes.
How many bars are there in Palmdale?
4 or 5.
Mr. Frederick, what prompted you to go to that bar this evening? Because you went there by yourself, and you were meeting Lucy there, right?
Yes.
But Lucy was the one who suggested the Horseshoe Club?
Actually, I was.
Really? And Lucy didn't say to you, no, I don't want to go there because I used to go there with David?
Well, that was brought up, but I reassured her it was all right.
You're a troublemaker.
I didn't see any problem. I didn't know David.
You didn't
Abbasi.
see any problem? Mr. Frederick, if you weren't looking for trouble for one reason or another, sir, you wouldn't have gone to the bar if she gave you prior notice that this is a place where David would hang out. And when she arrived and she saw him there and she said to you, let's go, I feel uncomfortable. And you said, not me, I'm not going anywhere. I want to sit here. So despite the fact that she was uncomfortable and that the presence of the two of you was just an exacerbating circumstance, you decided to stay. Now, I'm not sure about on a legal level, but on a moral level, you got what you deserved. You look for trouble, it's going to find you. You know, there's certain things your grandmother says to you that are true. And one of them is, if you look for trouble, you're going to find it. Right?
Yes, Your Honor.
But you visit your troubles on me and the taxpayer. Because this process cost money. And because you decided to be a macho jerk, you cost the taxpayer money. Whether it's in this court and any other court. You're gobbling up court time for people who really have cases over which they had no control. You had plenty of control. I didn't go to another one of the 4 bars in Palmdale. Or when you went in there and you saw him there, you knew who he was, and Lucy said, let's go. You got up, paid for the drink, and you leave. Right?
Right. That's what my plan was, but I didn't take fast enough action.
Okay. Did you file a police complaint, Mr. Frederick?
Yes, I did, Your
I'd
Honor.
like to see it, please.
I filed that the day after.
Why the day after, sir?
I was going to file it at the bar, and had I done so, he would have been incarcerated. I wanted
necessarily.
I wanted to take care of my ankle. It was hurting and it was broken.
So you went immediately from the bar to the emergency room?
Yes.
Okay. Well, evidently they did an investigation, and they didn't arrest Mr. Abbasi for assault. Do you know why, sir?
Basically, they couldn't find him, and DA didn't want to prosecute because it's a typical bar fight. They see it a lot, so they didn't feel it.
Because it's just as possible that you lost your balance because you were drunk.
I wasn't that drunk, Your Honor.
How do I know that? You don't have to be that drunk to trip. Mr. Frederick, I said something to you before, sir, and what I said, you may sit down. What I said to you before is if you look for trouble, you're going to find it. Now, I don't necessarily think that it was Mr. Abbasi's intention to get into a confrontation with you that evening, but it is clear to me that it was your intention to get into a confrontation with him. I say that for the following reasons. I am now summing up. Your girlfriend told you that she was going to meet you that evening. You discussed going to the Horseshoe Bar. She said, I don't think I want to go to the Horseshoe Bar because that's where David hangs out. You said, I don't care, I'll meet you there, don't be ridiculous. You go there, and sure enough, when she shows up an hour later, after you've had a couple of drinks, she says to you, I don't want to stay because David's at the other side of the bar. And you say, I don't care. Let's see what goes down if we stay here. It seemed to me, Mr. Frederick, you got the girl. You should be a happy guy. You shouldn't be looking for trouble. The girl that you're living with, the girl that you're happy with says, I'm not comfortable here. You pick yourself up and you leave. Chose not to do that. He pushed you. You fell. You broke your ankle. That's an accident. Goodbye.
All parties in the matter of Ng versus Riley. Step forward, please.
Eye care professional Monica Ng is suing her one-time golf partner, technical consultant Steve Riley, for medical and dental bills. Monica says she was hit in the face by Steve's golf ball.
Missing, according to your complaint, you were playing golf and you were in a foursome?
Yes.
And Mr. Riley was in your foursome?
Yes.
And you got hit with a golf ball that he sliced. You want him to pay for all of your medical bills, you had dental problems, et cetera, et cetera. And Mr. Riley says, sometimes happens when you play golf. Not every shot's a perfect shot. It's part of the risk you assume when you play the game. That's your defense.
Yes, ma'am.
When did this happen, Miss Ng?
On January 31st at the Lakewood Country Club.
And how long have you been playing golf with Mr. Riley?
I've never played with him before.
So you were teamed up that day?
By the starter at the country club.
What hole were you playing when this incident happened?
The 9th hole.
And who teed off first?
The guys teed off first, and then I teed off last because I tee off from the ladies' tees.
After you teed off, everyone left the tee. Is that right?
Yes, we all walked to our balls.
And was your ball in front of Mr. Riley's ball?
It was horizontal, diagonal to his ball.
And he shot first?
Yes.
And you were watching him?
Yes, I was watching him the whole time.
Why didn't you stand behind where he was?
For slow play, any reasonable experienced golfer would walk to their ball so that you don't delay play, because slow play is the #1 problem with golfing.
No, the #1 problem with golfing is getting hit with a golf ball. So when I was reading your complaints, and I've been out on a golf course, although I am not a proficient golfer, since I don't know who I'm playing with, as you didn't know who you were playing with, and you're not sure of their skill, I wouldn't get into a position where you were anywhere in harm's way. I would stand well behind that person.
I felt I was not standing in a location where I was in harm's way.
But you were, right? Because you didn't play golf with him before. You didn't know whether he was a good player or a bad player, whether he sliced, whether he was straight, whatever. But you don't think that you have any responsibility to worry about yourself?
Yes, I have the responsibility to worry about myself, but I was standing in a location next to my ball. I was watching him the whole time.
You think he aimed at you?
No, he did not aim at me. It was an accident, but still, he's liable for any damages or injury caused by his actions, as stated in the golf course rules at the Lakewood Country Club.
Well, I'll take a look at the rules of the Lakewood Country Club and see what they say.
Safety practices.
Let me see what the safety practices are. Yeah, well, this says that any person entering or playing on the golf course assumes full responsibility for his or her personal safety. That's you. And property. Players are liable for any accident, injury, and or property damage caused by their actions. Well, you're saying that his actions caused you to be injured.
Correct.
I'm saying your actions caused you to be injured. Miss Hang, my dear, when you play golf, there's a golf ball. That golf ball doesn't always go where it's supposed to go. Have you watched professionals play golf?
Yes.
Have you seen professionals sometimes slice their ball and it goes into a gallery?
Yes.
You think that they're liable if their ball hits somebody? They're not. Players not liable. That's what the game is about. Somebody hits a very hard ball. Sometimes it goes where it's supposed to go. Sometimes it doesn't go where it's supposed to go. If it always went where it was supposed to go, nobody would watch the game.
We have a verbal agreement after the injury. He was very apologetic for hitting me.
Yes.
And he gave me a cellular number so I can contact him so that I can get his home address to mail him the medical expenses.
Did you say that you would cover the medical expenses, Mr. Riley?
What I said was that if she wanted to go to the emergency room right then, I would help her with expenses. I did not say I would cover a week off of work. I did not say...
Absolutely not.
Right.
You're not responsible for a week
Right.
off from work. You're not responsible for her pain and suffering. You're not responsible for any of that.
Right.
So did you give him the medical bill from the emergency room?
I had not received it yet when I wrote him that certified letter.
Fine. What was your bill from the emergency room? $602 with the emergency bills. Is that right, sir? Now that you agreed to pay, according to you.
Yes.
Fine. Anything else?
Yes. A few months later, I noticed that the back of my tooth was swollen, and I went to the dentist, and that's when they told me that I have ligament damage due to trauma.
Could be. That's not what he agreed to pay for. He agreed to pay for your emergency room bills. But for the fact that he agreed to pay for the emergency room bills, he would not be responsible. You assumed the risk when you got on the golf course of whatever happens when you play golf, unless, of course, he picked up his club and flung the club in anger, or if he hit you with his club, or if he ran you over with a golf cart. That you don't assume the risk, but you do assume the risk that somebody may not hit the ball straight, so you have to make sure that you don't put yourself in harm's way. And if being in a position where you were a little bit of a slow player is more important than keeping yourself out of harm's way, that's a choice that you make. He can't guarantee where his golf ball's going to go. If he could, he'd be Tiger Woods' partner, right?
Absolutely.
Judgment for the plaintiff in the amount of $602. Thank you.
And now the next case.
All parties in the matter of Collingwood versus Berkelin, step forward, please.
Jeff and Tamara Collingwood are suing Tamara's brother, sales consultant Jim Berkland, for the unpaid balance and damages on a 1999 Mazda Protege.
Miss Collingwood, this is your brother.
Yes, correct.
From what I gather, about 4.5 years ago, you had a car that you were leasing.
Correct.
And your brother was just getting married, and you made an arrangement with him to take over the payments on the car. And at the end of the lease, the arrangement was that he was going to buy the car.
Correct.
Is that right, sir?
Correct.
And he did, for 4.5 years, pay for the monthly payments on the lease, and then decided he didn't want to purchase the car. So you want him to pay the turn-in fee that you had to pay for the car, and in addition, the car was damaged while it was in his care over the 4.5 years, and you had to pay several $1,000s to have the car fixed before you could turn it in. So you want the out-of-pocket expenses that you incurred as a result of his use of the car, right?
Correct.
So?
Judge Judy continues in a moment. Collingwood claimed Tamara's brother, Jim Berkland, owes for breaking a lease on a Mazda Protege. The couple also claims Jim severely damaged the vehicle.
Now, you acknowledge that the car was damaged while it was in your possession.
Yes, ma'am.
And it wasn't just recent. It happened several times while the car was in your possession.
Yes, ma'am.
Why didn't you purchase the car as you agreed to 4.5 years ago?
The agreement was $5,000 at the end of the lease. They said they might be able to drop it down a sum. When my bank told me it was $6,400, I told them I'm not going to pay that much for the car for the last 4.5 years. Basically, I paid $18,000 out of my pocket already on the vehicle. I said I was not going to pay the $6,400. You can keep the car. Then they informed me if I turn the car in, it will have to be a $300 turn-in fee, which I was not aware of. Plus, I had to fix all these things that was wrong with the car. That was a lot of it wear and tear, windshield cracks, whatever, chips from rocks. I told them they can have it. I went over and parked it in the parking lot, told them where the keys were, take it, get out of my face. I wasn't going to purchase the car at that price that we did not agree upon.
Is that right?
Incorrect. I told him it'd be around $5,700, and there's tax on top of that, too.
Okay. So what you really did was you stiffed your sister.
No, ma'am. They stiffed me.
No, they did not. Did you go out and buy another car?
Yes, ma'am, I did.
What year car did you buy?
A 2000.
And what year car was this?
A 99.
Did the car that you bought have the same kind of damage that is the car that you turned in?
Yeah, probably.
What do you mean, yeah, probably? Don't be a smart aleck with me.
It was pre-owned.
Oh. Listen, it's not my fault that you have an obnoxious brother.
I know.
But if you had an obnoxious brother, I would not have made a business arrangement with him. Because anybody that's not only obnoxious but not smart because he thinks that he can get away in front of me with being obnoxious and stupid.
His whole life that way.
Well, but you entered into a business relationship with him.
Looks I love him.
I mean, the guy's an idiot.
Yeah.
Listen.
Got a lesson learned.
How old are you?
31.
Are you a married person?
Currently going through divorce.
Sounds like a smart girl to me. You have children?
Yes, ma'am.
How many?
1.
How old?
4.
What kind of work do you do?
I'm sales consultant.
Are you on salary or commission?
Commission.
At least people are smart enough not to pay you a salary. Now, you made a business arrangement with your sister. You made an arrangement with her that she would turn over her car to you, a car that she had a lease on, because clearly the reason you did that was because you lacked sufficient credit to do the deal yourself at that point. I assume that that's true because if you had sufficient credit, you would have gotten your own lease, you would have made whatever kind of an arrangement you wanted, but you thought that this was a good deal. So it is clear to me that you would not have entered into this arrangement with your sister if you didn't feel as if it was to your advantage.
You know,
so
ma'am,
I'm speaking. So what you did was you entered into an agreement with her, and at the end of the lease, who are you?
I'm Nick. I'm here to support my friend.
Nick, I just want you to sit there and be quiet and don't smile. Just sit there and be quiet. At the end of the 4.5 years, you realize, why am I going to pay for this old piece of junk that I haven't taken care of over the 4.5 years? I can probably get myself a car much cheaper, and who cares if I screw my sister? Can I please see what it cost you to fix the damage on the car
And
that
also,
he did?
Can I say something, ma'am?
This one. Also, he was aware of the damages that he did at the car, because every time he did something, he would tell us.
Explain to us how he did it.
Yeah, he told me how he did it. He hit a curb, he hit a tree, whatever. He hit things. I don't want to see that. All I want to see are the bills.
Sorry.
Okay.
Can I see the payout, please?
We haven't received the bill, but it has not been paid for yet.
Well, let me see the letter from them indicating that they are going to come after you for...
We have not received, at this date, we have not received anything from them, and I have not called them to ask for it.
Oh, listen to me very carefully, Miss Collingwood. I will enter a provisional judgment in your favor pending receipt of the bill. Okay. And the check will be made out to the lender, not to you, if they come after you for the bill. But certainly, I'm not going to direct that he pay you if there's a possibility that you're not going to have to pay them. Yes, now you can speak.
Ma'am, she told me $5,000. She didn't tell me $5,700. They said $5,000. I might be able to drop it to you less. Sure, there's damage on the car.
Just a second. Who is they said? Listen to me. Who is they that said I may be able to drop it to you less?
My brother-in-law, Mr. Collingwood here.
He's not making any money from this. He just wants you to pay off the car. You go into a lease arrangement, you find out exactly what the monthly payments are, what the buyout is. You find out.
I asked 4 times.
You don't ask
him. Over 4 years, I asked them for a lease agreement. They would not furnish it to me. I had no idea what I was getting myself into.
That is not true.
You didn't give me a lease agreement.
Listen to me, Mr.
Did
Buckland.
you furnish me a lease agreement?
No.
What don't you understand?
Constantly.
What don't you understand? Don't speak to him. You're in a courtroom. You're not at a tea dance. You're in a courtroom. You don't speak to him. When you enter into a lease, what you do is...
I didn't enter into a lease, ma'am.
Oh, yes, you did. Oh, yes, you did.
I didn't sign nothing.
Please.
I paid their car payments and helped their credit out for the last 4.5 years.
Right. I have great credit.
Shh.
Yeah, thanks to me.
What's your wife's name?
She asked me not to mention on air, ma'am.
Good.
She's just wife.
Mrs. Berkeland.
Yes, ma'am.
Smart lady. She has a chance of recovering a life. Judgment for the plaintiff provisionally in the amount of $2,100 as soon as I get the bill. That's all. Thank you.
Thank you very much.
Excuse, you may step out. Yes, case number 246 on the calendar in the matter of Potters versus Wells. Parties have been sworn in, Judge. You may be seated, sir. Have a seat.
Miss Potter, the defendant is your former husband.
Yes, ma'am.
And your claim is for 2 things. First, you claim that he filed a report to Child Protective Services, causing you some stress.
Yes, ma'am.
The second has to do with an income tax bill that emanated from the time that you and the defendant were married, that you're paying.
Yes, ma'am.
Mr. Wells says that he was concerned about his daughter. You have a daughter together.
Yes, we do.
And he doesn't deny that he called Child Protective Services.
Yes, ma'am, I did.
And that he pays child support, so the tax bill is yours.
Yes, ma'am, that is correct.
So let's deal with those 2 things. Ms. Potter, when were you married and when were you divorced?
We were married May of 1996, separated in December of 99, legally divorced January of 2001.
And when was your daughter born?
She was born August 19th, 1997.
And you have visitation with your daughter?
Yes, ma'am, on the weekends.
And you pay child support?
Yes, I do, diligently.
Now, Mr. Wells, when did you call in a report to Child Protective Services and why, sir?
It was about a month ago. I noticed a change in my child's demeanor, calling me during the night, crying, saying that she did not want to be there anymore, that it was a bad place to live, they were being mean to her, which I've heard before. Taking that she's 7, probably some discipline going on over there, so you try to take that in, to occurrence. But after a week of this, and even in the mornings, I heard her and her mother arguing, and the child terribly upset before she went to school. So then that following weekend, she tells me that this gentleman over here had beat her with a belt. That,
who is this?
This is my boyfriend.
All right. Which really concerned me. Did a flip on that one, that he had took some pictures of her in her room. So I called Child Services, and I spoke with the lady, and I haven't caused them any grief in the time they've been together, haven't, interfered in their lives. And so after explaining this to the Child Services, they felt like that I should file a complaint with them. And that, needless to say, leaving the child alone at the bus stop, getting off at the bus, wandering around the neighborhood for a half an hour unsupervised, sitting on the front porch waiting in the afternoon for 15 to 20 minutes at a time without no supervision. All of these concerns came out in that.
Okay. But primarily you called because of the photographs that your daughter told you were taken
Absolutely.
of her, and the fact that she said that this gentleman disciplined her with a belt.
Yes, ma'am, absolutely.
Okay. What's your name?
It's Rob Brialt, ma'am.
Step up. Last name?
Brialt,
How long have you and Miss Potter been together, Mr. Brialt?
about 1.5 years now.
And you live together?
Yes, ma'am.
Do you have children?
Yes, I do. 3 of them.
And where do they live?
They live with their mom in Colorado,
And where do you and Miss Potter live?
in Cary, North Carolina.
Did you ever discipline Miss Potter's daughter?
Just once, ma'am.
And tell me about that incident.
My children were visiting me for approximately about 5 weeks, and all the girls were up in one room sleeping, or supposedly sleeping, and they're right above the TV room, you know, where we're watching TV, and you can hear them talk and all that, and yell up there a couple times, you know, go to sleep, girls, it's getting late, go to sleep. Since the 2 of mine were obviously up there, and they're acting up, I went up there with the belt, and, you know, spanked them, slapped, you know, gave them a hit on the rear end, you know, to the 2 of my girls, and it would be only fair to the other 2 to not play favorites with Tatum. So she got it as well. And then they all quieted down and they all went to sleep.
Might I add, she did, it was a swat. She didn't even cry. It wasn't a spanking.
To Miss Potter.
Okay, sorry.
That's really not an issue that's before me. What's before me is your claim that he called Child Protective Services without a basis. So that's what I'm trying to get to.
Okay.
Then there's an issue of photographing your daughter. Now tell me about that. Have you photographed your daughter in her room?
What led up to that? Tatum was supposed to be upstairs cleaning her room. I yelled up, Tatum, are you cleaning your room? Yes, Mommy. So Rob's like, well, we'll see. He took this phone, a camera phone, you know, most of them have it. He peeked around the stairs, snapped her sitting on the floor playing when she's supposed to be cleaning her room, came downstairs, downloaded on the computer, showed me, Tatum, come down here right now. She came down. I'm going to remember, Mommy always says she has eyes in the back of her head. I can see everything you're doing. What's this? She looks at it. I'm like, you weren't cleaning your room. She's like I'm busted. You
Nothing
know?
terribly wrong with taking a picture and saying, listen, the picture, this speaks 1,000 words, you weren't cleaning your room. But as it's relayed to her father, that doesn't sound good. Do you understand?
You're absolutely right. Tatum came home one weekend from his house, said, Dad's going to call child services or something on you. I'm like, what? And she's all, yeah. And she told me why. So I get on the phone. I'm like, what are you going to do? Tatum's telling me you're going to do this. And he's like, yeah, I have a concern, my daughter. I'm like, that's a very good concern. This is what happened.
Miss Potter, let me dispose of the first part of your claim. And I want you also
Yes, ma'am.
to listen carefully, Mr. Wells. Is this your only child?
Yes, ma'am, it is. Or, I beg your pardon, I do have an older son in California.
How old?
13 years old.
Little girls sometimes are manipulative.
Absolutely.
And let me dispose of Mr. Brialt first so that he can sit down. Never discipline her child with an implement. Shouldn't discipline her child anything other than with words anyway. But you have no right to discipline her child with a belt. Period. End of discussion. You're not even her stepfather. You have no relationship to this child at all. And the fact that you wanted to be fair because you were disciplining your children, and so you wanted to be fair and your children shouldn't be angry with you, so you disciplined our child, that's ridiculous. Because there are other ways of telling the 3 little girls who were upstairs playing to be quiet because they were interfering with your television time other than taking a belt and going upstairs and hitting them. We understand each other?
Yes, ma'am.
Sit down. He hasn't assumed the legal responsibility in any way to your daughter. Even when he does, I wouldn't let him discipline my daughter corporally. But certainly not as long as he's just your boyfriend. What kind of commitment is that?
Judge Judy continues in a moment. Angela Potter says ex-husband Michael Wells maliciously filed false charges with Child Protective Services. Angela also says Michael owes for back taxes.
So when his daughter complained to him that she was hit with a belt, that was true. And as a non-custodial parent, because he has visitation, and he's concerned that A, some stranger in the house is hitting my child with a belt, and the mother isn't doing anything about it, and the same stranger is taking pictures of her in her bedroom, because that's the way it's presented.
Right.
He has a legitimate complaint. And I do not find that he maliciously called Child Protective Services because you've been separated since 1999. This is 5 years later. Is this the first time he's called Child Protective Services?
Yes, ma'am.
And he had a reason to do it. And I don't care whether you explained it to him or not. You can't explain to him satisfactorily that this man took a belt to your daughter. There's no satisfactory explanation for that.
Okay.
Now let's get to number 2. Let's get to the tax returns. Can I see the tax bill that you got with regard to the taxes owed?
Well, here's the whole statement from 1998.
It's just a retaliation suit, ma'am, is all. She threatened, as soon as Child Protection Services was contacted her, she called up.
Mr. Wells.
Yes, ma'am.
Listen to me very carefully, my friend.
Yes, ma'am.
Was the first part of my judgment fair to you?
Yes, ma'am.
So you think I'm a fair lady?
Yes, I do.
I don't care whether it's in retaliation or not. If she's been paying off your debt, I'm going to find out why.
Okay.
Well, this says, sir, at the time when you were still married and still together, there was a deficiency in your tax returns of almost $9,000. How much of it did you pay?
Haven't paid any of it.
Why?
Because all my tax returns goes to child support. It's mandated by the state. They take my tax returns and apply it towards state arrears in child support.
Just a second. So what you're telling me is that they take your tax refunds because you were a deadbeat father with regard to your child support, either for this child or another child.
During the arbitration of the separation, yes. I did go a period of time because Ms. Potter had...
You were a deadbeat with regard to either this child or your son.
I wouldn't call it a deadbeat.
Deadbeat doesn't pay child support as directed. That's a deadbeat.
Well, it wasn't paid until mandated by the court, ma'am, and then it has been paid every month since then for the last 5 years.
Well, arrears suggest, Mr. Wells, that the state has determined that you owed money for one child or two.
For 2 children, I paid.
For both children. So I'm going to ask you the next question, sir.
Yes, ma'am.
Why didn't you start to pay her and say, listen, we have $9,000 that we owed. Clearly, half of that is mine because we were married and filed jointly. So what you're telling me is you decided that she's got to get stuck with this tax bill. Is that what you're telling me?
No, ma'am. I just thought that $9,000 was strong for one tax we filed together 1 year.
So?
And she hasn't, applied me with any documentation, has a contact.
Here, just a second. Here you go. I want him to have the documentation.
Absolutely.
Take a look.
$8,881.
That's what it says.
All right.
So, since you filed those taxes, since you were living together, were you working at that time, Mr. Wells?
Yes, ma'am. As a subcontractor at that point.
Very good. And what were you doing?
I was an executive assistant for a recruiting firm.
Okay. And so far you've paid about $7,100.
Yes, these
and
are...
there's, right, I see it. And there's still $2,030 owed.
Penalties and interest, pretty much.
Mr. Wells, the defense that you have to this, as I indicated before, because I've read it, your defense is, as far as our taxes, my wife filed our taxes and they are in her name. That's what you swore to. Internal Revenue Service says that you filed married filing jointly.
Absolutely.
So that is incorrect.
Yes, ma'am, it was. But that was the first time I'd seen that piece of paper right there.
Good. Well, I'm glad that you saw the piece of paper, Mr. Wells, because you owe her $4,500. That's half the tax bill and penalties. Judgment for the plaintiff. That's all.
Thank you.
All you are excused. You may step out.
And now the next case.
All parties in the matter of Alarid versus Ayala. Step forward, please.
Small business owner David Alarid is suing teacher Sandra Ayala for the cost of a chicken suit he sold to her via eBay. Sandra says the suit was supposed to be brand new, but instead it was old and dirty.
Mr. Alarid, you advertised this chicken costume on eBay.
Yes, ma'am.
The defendant purchased it and then somehow paid for it with this PayPal or PenPal, I don't know, something, pal, that I don't quite understand. But the bottom line is she canceled the payment that she made to you and she kept the chicken suit. Okay, so $154 was the amount of the purchase plus shipping, and you want $2,650 for the price of the chicken suit plus your aggravation.
Yes, ma'am.
That's a lot of aggravation, Mr. Alarid. And Miss Ayala says she purchased this as a result of an ad that you placed on eBay, and she said you advertised for a
new, never been worn chicken suit.
New, never been worn chicken suit. She purchased it in good faith, she sent you the money in good faith, and she got this dirty, disgusting, worn chicken suit, which she doesn't want, right?
Correct.
and which she's not going to pay for. Now, when did you purchase it?
This was in May, early May.
And what did you purchase it for? This wasn't something you planned on wearing, I assume.
No. I'm a special education teacher, and just on a volunteer basis, sometimes I throw events for the special ed kids in my area. So I had a couple of picnics and concerts coming up in the early summer, and we have some children's music, and there's a song about a chicken in it, and I thought it would be great to have a little chicken mascot.
Do you have a copy of his ad that he ran on eBay?
I think he brought the original ad.
Can I see it, please? Okay, here we go. New, never worn, deluxe adult chicken mascot costume. And is this the way it came?
This is the way it came.
Can I see it, please? Bird?
Sure.
Come on, have a little bit of a sense of humor, babe.
And bring the feet with the shoe prints.
Name is Bird. I take it kind of personal.
We've known each other a long time. Listen, this has been worn. Mr. Alarid?
Yes, ma'am.
So, how come you sold something that had been worn to her as brand new, never worn?
Well, when it was shipped, it was brand new, never worn. It was sold 5 months ago.
Okay, let me see. No, it doesn't look too awful. You bought it in May what?
I think the date was May 8th. It was May 8th.
Excuse me a minute.
Who gets it?
Let's keep it right here for a minute. Well, I haven't finished doing the case yet.
Okay.
May 8th. And when did you receive it?
Just about a week after that.
When did you notify them that you didn't want to pay for it?
Well, that's not. I did pay for it. I paid for it right away. PayPal is
You paid for it right away. Paid for it on May 8th.
Exactly.
Okay. Then you got it about a week later, say May 15th. Mm-hmm. And you realized that it was
worn.
It was worn. So what did you do?
I contacted eBay by email. That's the only way. And I contacted PayPal. And I said, what do you do in a situation like this?
Okay. Do you have any emails to support that?
I do have emails. I have emails between he and I. But the
No.
The PayPal.
I want to see.
This is the record of PayPal.
Let me see. Is this the first time you had bought something on eBay?
Yeah, it was my first time bidding on something on eBay, and so since I wasn't sure how to go about it, I had to call PayPal and said, what do you do when you receive a fraudulent item, when something comes worn and dirty and you didn't pay for that? And they said, oh, this man has actually refunded your money. I said, why? And they said, well, we can't be sure why, but you'll be getting the money in a day back to your account. And then he sent the email that said, PayPal accidentally sent you that money. You have to send it back to me. So I contacted PayPal again, and they say, we don't do refunds at all. It's seller initiated, and there are no accidents.
Now, when did you correspond with Mr. Alarid about the suit?
The day that the money came back into my account.
Was that also in May?
Yes.
So practically immediately?
Exactly.
Is all that correct, Mr. Alarid?
No, ma'am.
Okay. When did she contact you and let you know about the condition of the suit?
June the 14th, after I sent several emails, finally, out of desperation, eBay and PayPal advised me to file a complaint with the FBI Internet Fraud Division, at which point I sent an email saying, look, I'm filing a complaint with FBI Internet Fraud Division.
That was on June 14th?
Yes, ma'am.
How many of these chicken suits have you sold, Mr. Alarid?
On eBay or altogether?
Altogether.
Probably about 50.
50?
Yes, ma'am.
How many on eBay?
Probably about a dozen.
Where do you get them from?
Out of New York.
How much do you pay for them?
I pay $49.99, I believe it is.
So you pay $50 for
yes,
them?
ma'am.
She doesn't like her suit, so you either want the money or the suit back.
Well, it goes a little bit beyond that at this point.
She wants to give it back to you.
I asked for it back several times.
Yes?
And her emails, which I have right here, I have a copy for you.
Yes, I'd like to see them.
Okay. Here's the emails right here.
Well, she told you right away, sir. She said, I don't know what clerk you checked with about the condition of the suit, but that suit arrived in an old bag, in an old box, and the suit was full of leaves and debris, and the rubber parts were stained with marks on the beak, head, and shoe prints on the feet. They're still there. She told you that right away.
That was June the 14th.
So, she wants to give you the suit back.
I asked for it back.
Now you got it. Listen to me, Mr. Alarid. Are you in business?
Yes, ma'am.
Have you ever had complaints filed with regard to these chicken suits before?
Never.
So you paid for 50 chicken suits, which you paid $50 each for, equals $2,500. That's what you paid for the chicken suits. You sold 49 chicken suits times 124
Yes, ma'am.
equals $6,776. That's a fair profit. You made almost $4,000, and you've never had a complaint.
Correct.
Consider this the cost of doing business.
Oh, it's not a problem.
Perfect. Give him his chicken suit.
Okay.
Perfect. Now you have your chicken suit and your profit of almost $4,000. I would walk away a happy man, Mr. Allered. Thank you very much. This case is over.
Bodies are excused. You may step out.
Nurse Veronica Treitner is suing her daughter, 19-year-old waitress Jessica Unterberger, for her share of an insurance settlement. Veronica says Jessica cashed a check and took off with the money.
Yeah, this is case number 260 on the calendar in the matter of Treitner versus Unterberger.
Thank you.
You're welcome, Judge. Parties have been sworn in. You may be seated. Have a seat, sir.
Ms. Treitner, the defendant is your daughter.
Yes, ma'am.
And you are suing her because, according to what I read, your daughter was riding in a car as a passenger. Who was driving?
I was driving.
And there was an accident.
Yes.
And your daughter was injured.
Yes.
She was under 18 at the time.
Yes.
And you decided, rather than going to trial, because I assume the other person was responsible,
Yes.
you settled her claim.
That's correct.
For a little over $4,000.
Yes.
She wasn't living with you at the time, because your daughter has been in foster care for a good part of her adolescence.
That's correct.
And you sent her the check, because there was a two-party check, and you instructed her to sign the back of the check, send it back to you, and you would give her some of the money.
That's correct.
And she kept the check and cashed it.
Yes.
And spent the money.
Yes.
So you want half the money back for her medical bills.
That's correct.
Okay. How old are you?
I'm 19.
When did you go into foster care?
I went into foster care the 24th of May in 2002 is the official date.
Who did you live with before that time?
My mother.
Had you been in foster care at any time from the age of 12 to 16?
I went to foster care when I was 14 and I turned 15 in foster care.
You have siblings?
Yes.
How old are they?
My brother's 14.
Does he live with your mother?
Yes.
Has he always lived with your mother?
Yes.
He was not in foster care?
No.
So I gather from what you tell me, you and your mother had a rocky relationship, which is why she put you in foster care.
Correct.
And you have remarried?
Yes.
Now, you took her out of foster care because you were going on vacation or a trip?
That's not exactly true. We asked them if she could go with us. It's not so much that we took her out, but it was more like a trial to see if she could come back home and live with us.
And that's when the accident occurred?
Yes.
Tell me about the accident. When was it?
It was June 14th, 2002. We were getting onto the Pennsylvania Turnpike, and there was an 18-wheeler in front of us stopped. I stopped. The person behind me stopped. The person behind him did not. When he hit that car hit us. It bounced back and hit us again. Jessica was on the driver's side back. I was driving. The car, when it hit that side twice. We at first declined care because she said she was fine. By the time we got to New Jersey, she was complaining of symptoms of a whiplash. We took her into the hospital, and she did have whiplash.
Did the insurance company pay for the damage to your car?
Yes.
Whose insurance?
The person that hit us.
Did you sue on your behalf?
No.
Who else was in the car?
My husband was in the car, and she was in the car, and my son was in the car.
Anybody else injured besides your daughter?
Not in our car. I don't know about the other people.
Not in your car?
Right.
So what medical bills did you have for your daughter?
We had medical bills from the hospital in New Jersey where she was seen, and a hospital bill from a lab. I think it's in my paperwork.
Well, I'd like to see it.
This is the breakdown of where the money was supposed to go. It was for the radiologist. Everything else.
Did you pay these bills?
Yes.
Let me see.
I don't have the receipts. They were just paid for I think on my husband's credit card like 2 years ago, and we don't have the bill.
Your Honor, I was in foster care, therefore Medicaid paid for the bills. I was unable to get a hold of Medicaid. I was unable to get a hold of the hospital, but I do have copies of my physical therapy that I went through. payments, and it also, the highlighted section is Medicaid adjustments and Medicaid paid.
Can I see it?
We did not ask them to pay anything that Medicaid paid. Her physical therapy, anything that happened in the state of Ohio.
I just need proof that you paid these bills.
I don't have it.
Well, that's unfortunate, because if she was in foster care, your daughter is absolutely right. If she was in foster care, then the state pays for any medical treatment that she had.
That's true. However, regardless of whether her bills were paid or not, it says on there that she's supposed to get $2,000 only. The other $2,000 was supposed to be for her bills. I thought if they were already paid, I would not have to bring any more proof. I mean, it's to pay her bills.
Let me ask you this question. Which one is it? Is it that you paid the bills, or you didn't pay the bills, but you felt as if $2,000 was supposed to be towards the bills, so you should be entitled to that? Which one was it?
The bills were paid.
By whom?
I paid them, and my husband paid them. They're on his...
All you have to do is show me.
I can't.
Listen to me, Miss Trentner. Even if you didn't pay and Medicaid paid, only $2,000 of that $4,000 check was to go to your daughter, and you as her parent would be entitled to the other half.
No. The other money was to pay the bills. She was only entitled to...
Listen, I do not believe, madam, that... Stop playing with the paper. I do not believe that you paid the bills. I'm going to tell you why I don't believe that you paid the bills. First of all, you don't have any evidence that you paid the bills, and you don't look like an unintelligent woman. And if you're coming to court and saying, and your complaint says, half the money was to pay for the bills, that is your whole case. Your whole case is the bills.
No, ma'am, that was not why I wanted to see the judge. Why I wanted to come was because when I sent Jessica the check, she forged my name and took any money, period. It's the fact that she forged my name, or she had somebody forge the name on my check.
Then what you're saying is, it's not because you spent your own money out of your pocket to pay for her medical bills that you should be reimbursed for. You came to court and you wanted to see the judge because your daughter had forged your name and taken all the money.
Ma'am, that is correct. However,
all right.
Can I say one more thing?
Yeah.
I don't care at this point about the $2,000 that is in dispute, whether you say I owe it or whatever. And you can keep the $2,000. I don't care. The dispute is she forged my name on the check.
And?
I would like her to have to pay for something that she's done wrong at least once in her life.
Ms. Triton, your daughter was under the age of 18 at the time you sent her this check, is that right?
That is correct.
And so she was still technically your responsibility?
No, ma'am.
She was your responsibility. You chose to abdicate that responsibility by putting her in foster care.
Can I tell you why she was put in foster care?
Sure.
When she was about 12 or 13, she started to hit people, and she would not stop. We had her arrested at least twice for domestic violence before she was put out of my house. I told
Ms. Triton, is it normal for a child who's 12 years old to act out in that way?
Yes, but...
You think it's normal for a child of 12 years old to act out in that way?
No, I don't.
Okay. So what did you as a parent do while she was living with you in order to try to get to the root of the problem as to why she was acting out in that way?
We sent her to counseling. I went to counseling with her. We tried to take my mom to counseling. We tried to get my son to
What do you mean you
go.
tried to take your mom to counseling?
My mom lived with us, and she would not go to counseling.
Well, was there a problem with your mother?
There's many problems with my mother, Judge.
Well, what was the problem with your mother and your daughter? What was the problem with your grandmother and you?
The main thing was before we had moved in with my grandmother, because for the longest time it was just me, my brother, and my mom. And then we decided, because my mother was working all the times, and me and my brother were from babysitter to babysitter, that it was just easier for us to live with my grandmother so she could watch us. Before we moved in with my grandmother, everything was fine. We were kids. We were allowed to go hang out, play with our friends, whatever. We moved in with my grandmother, and all that stopped. My brother was still allowed to do whatever he wanted, and I was constantly on lockdown. I wasn't allowed to talk on the phone, wasn't allowed to go hang out.
What do you mean you were on lockdown?
I was in the house 24/7. I wasn't allowed to go hang out with my friends. I wasn't allowed to go do anything school related.
You mean your grandmother was strict with you?
Yes.
Okay. And you tried to get your mother to go to counseling?
Correct.
And your mother refused to go to counseling?
Exactly.
I assume you wanted your mother to go to counseling because you felt as if some of her behavior was not appropriate.
I felt between my mother, me, and Jessica that there was an issue that we needed to get to the bottom of. Yes.
Okay. And your mother refused to go?
Yes.
Your daughter went?
Yes.
You went?
Yes.
She's 12.
Actually, she was a little bit older.
She's 13. She's 14. I understand that you were a single mother and you had 2 children, but you put your daughter in a situation that you acknowledge was not the best situation for her with your mother, with somebody who refused to address any problems that there were, and you responded to that when your daughter started to act out, which I'm sure she acknowledges was inappropriate, inappropriate behavior, but she started to act out. Your response was, instead of moving out of your mother's house, you put her in foster care.
That's not exactly true. My mom lived with us because she could not work. She had nowhere else to go. My brother wouldn't take her. Nobody would take her.
Just a second. Is what you're telling me now that you had to make a choice between your mother and your daughter?
No.
That your mother had no place else to go and you couldn't put your mother in foster care, so you put your daughter in foster care?
No.
Come on.
No, that's not what I'm saying.
Well, I mean, I'm trying to get what's happening here.
Can I kind of explain it? Jessica would go from hitting, then she went to punching. She tried to choke me. She went after her grandmother with a butcher knife. The reason that I finally put her out is because I told her, if you ever hit your brother, you cannot stay with me anymore. I put up with a lot of stuff. Even when she went to counseling, we found an excellent counselor for her, was working wonders for her. Then she decided that she didn't like him, and then she wouldn't talk to anybody. So when she hit her brother in the face, that's when I told her that she was no longer welcome in my home, because she was my daughter, and I didn't know what else to do.
Okay, so that's, just a second, so that's what you did. And then you had a problem with this check. Now, you don't have to answer me as to whether or not you forged your mother's name. You forged your mother's name, you cashed the check. That's what you did, right?
Correct.
Okay, what'd you do with the money?
I was living in my own apartment, and I needed furniture for my apartment.
How old were you when you were living in your
I was 17.
Okay.
Foster care has a program called independent living, and that's what they did. They put me in independent living. I needed pots and pans, dishes.
Okay, so you were living in an apartment?
Correct.
Did you know that she was living by herself?
Yes, I did.
Good. What did you do to help her set up in her apartment?
When she set up in her own apartment, we were already in New Jersey.
I didn't ask you where you were. I said, what did you do to help her set up in her own apartment?
When she called me, I asked her if she needed anything. She told me no, she was fine.
So the answer that you're telling me is you did nothing for her to set her up in her own apartment at age 17.
I asked her if she needed, right, that's correct.
Judge Judy continues in a moment. Treither says her daughter, Jessica Unterberger, stole her share of an insurance settlement.
Okay. So she says she needed furniture and pots and pans and she needed some money. Were you working?
Yes.
What kind of work were you doing?
I was working at a pizza parlor.
Are you still working there?
No, that was in Ohio. I currently live in New York now.
And what do you do in New York?
During the summer season, I'm a soccer referee, and right now I'm working as a waitress.
Where?
At a restaurant in the East Side.
You live alone?
Yes.
That's a hesitant yes.
Because I'm living in a room in a house. There's other people in the house, but it's my room.
So you rent a room?
Yes.
What's your rent?
$120 a week.
And how long have you lived there?
I've lived in this particular place for about 2 weeks now.
Prior to that, where were you living?
I was living in Ridgewood in another one room, and I was paying $90 a week there, and I lived there for 3 months. And before that, I was living with my fiance's parents.
And that didn't work out?
No.
So from the time you were 17 until now, you've taken care of yourself?
Correct.
You got my drift.
I don't understand why you want to believe her, because what she's telling you is not true.
Just a second. I'm asking you, you're her mother?
That's correct.
From the time she was 17 until today, other than this $2,000, how much money have you given your daughter?
None, because I did not know where she was.
Now you know where she was. Whether you know where she was or you don't know where she was, you've given her nothing, and she's managed to support herself.
If that's what you want to call it.
Well, she's managed to support herself.
But what she's telling you she does for a living is not what she does for a living.
Well, tell me what she does for a living.
She has tried to sue the state of New York twice.
Yeah.
She has lied to you about where not where she lives, but who she lives with. And
listen to me. I asked you a simple question. You said to me she lied about what she does for a living. And I'm asking you if she lied about what she did for a
Yes,
living.
she did.
You tell me what she does for a living. Suing the city of New York is not a living.
understand that.
All right.
The last, what she told you and what she told me was that she works in a restaurant and she gets paid under the table.
Who cares?
But that is not true.
Well, so tell me what she does.
I'm not sure. But I know she doesn't do that.
Let's try it now. Let me tell you something. I was concerned.
You know what?
I'm speaking. I was concerned about your lawsuit from the beginning because it seems to me that you were.
Again,
I'm speaking. You were in a car. You were the driver of the car. Your minor daughter was injured in an accident that, according to you, and I have no reason to doubt you, was not your fault. I have children, and if one of my children was injured in an accident, and the accident resulted in that child getting a claim, why don't you try paying attention instead of crying because you're not going to get any money?
I don't care about the money.
Then just listen. Then just listen. It would seem to me what I would do is I would say, gee, here's $4,000. I'm going to put this in an account for my child, for their future, either for college or to set them up in an apartment or to help them maybe with a car. But certainly, I didn't pay out any money because I had insurance that covered the medical bills.
That's not true.
And you didn't pay any money because I don't believe that either you or your husband paid any money, because if you did, you would have the canceled check. You would have your credit card statement showing that you paid the amount 2 years ago, because if you knew you were coming to court and that's the evidence that you required, that's the evidence that you would have. You say you're angry because she forged your name and she should be taught a lesson. Well, it was the wrong thing for her to do, to forge your name and to take the money to use to set up an apartment. But at the time she was 17 years old, she was placed in independent living, had your own apartment. You were working marginally to pay for whatever was in the apartment, and she needed the money. And since you weren't forthcoming with the money, and you knew how to reach her, because you knew where to send the check, you sent her the check and said, darling, sign the back of this check. When I get the money, I'll give you half.
That's not what happened.
That's what you told me in your complaint.
That's
You
not-
said, you want me to read you what you wrote? You said, I sent her the check unsigned. I sent it by certified mail.
That's correct.
Okay, so you knew where to send it.
Right after that.
Yeah, just a second. So you knew where to send it. And if you knew where to send it, was she in foster care or was she in her own apartment?
She was in her own apartment at that time.
And how much had you given her at that time to help her set up an apartment? A little slush funds.
Considering that I had just found out that she was on her own, I couldn't have sent her anything, could I have? I did not know.
Yes, just a second.
I did not know.
Yes, my dear, you could have. You could have said, here's $4,000 that I just got. But I'm speaking. You're on your own. I'm signing this check over to you, my sweetheart. I know you've had a difficult teenage time. We haven't always gotten along, but you're on your own now. Here's $4,000 that none of us anticipated because you decided to settle the case for her. Here's $4,000. I want you to take it. Whatever you don't need, listen, whatever you don't need to set up your apartment, put in a bank account and use it with my love. Because part of it should come to me, I'm giving it to you. That's what you should have done. You didn't do it then, you're doing it now. Your case is dismissed, that's all.
I can't believe this. You win again, you stupid.
21-year-old student Kaylin Zilmer is suing her ex-roommate, 21-year-old student Jennifer Zemlicka, for breaking an apartment lease. Jennifer says Kaylin's partying made living with her unbearable.
Yeah, this is case number 269 on the calendar in the matter of Zilmer versus Zemlicka. Parties have been sworn in, Judge. You may be seated. Folks, have a seat, huh?
Ms. Zilmer, how long did you room with the defendant while you were in college?
We have lived together for 2 years.
And then, according to your complaint, you recently signed another year's lease.
Right.
And the defendant moved out prior to that second lease starting, leaving you to pay 14 months rent.
Right.
On your own.
Yep.
The year on the new lease plus 2 months on the old lease. And Ms. Zemlicka says that she absolutely moved out because you invited people to the house, you had underage drinking parties, people either stole her property and or damaged her property. It was really unsafe for her to stay there, and that you should have tried to get a new roommate for the new lease. or gone to the landlord, tried to negotiate out of the lease, but she is certainly not responsible. When did you, Ms. Zemlica, start to have problems with the plaintiff with regard to who she was bringing into the apartment?
The first incident where I began to feel that things were unsafe occurred on January 25th, 2004. During that weekend, I was not present at the apartment. I had gone to my hometown, to my parents' house, and during that weekend, Kaylin Zilmer had several people over, and there was an underage drinking party that occurred.
How did you know that?
I know that because I was told by both the plaintiff and by a mutual acquaintance of mine.
Well, you can't tell me anything about the mutual acquaintance. Did you have a discussion with Ms. Zilmer?
Yes, I did.
About it? Tell me about the discussion.
I came back from my weekend away, and she told me that she had had two friends over and that they had been drinking, and that they had been drinking quite profusely. And one of
well,
the
she didn't say that. She didn't say they've been drinking. Listen to me.
Okay,
Ms.
she
Zemlica,
said that they had been drinking.
Okay, Ms. Zemlica, don't embellish. If you embellish, I think you're lying, and if you're lying, I'm not interested in hearing you. Do you understand?
Okay. Yes.
All right, that was January 25th. Let's move on.
Your Honor, there was another event that occurred on January 25th
well,
that
let me hear
concerned
about
me. Jason was there, and he drank so much that he vomited blood in the bathroom. The paramedics were called. 911 was called. Although all three of them were underage, no tickets were issued.
Not true, Your
January 25th, what happened?
I gave no alcohol to this person who came over.
Well, who was the
friend.
person?
He brought his own alcohol.
Who was the person?
It's a mutual friend of ours.
And he was drinking so much he got really sick.
You're right, and we did call 911.
Okay, fine. What's happened next?
After January 25th, although the incident worried me, I figured it was a one-time event.
Let's get on.
Okay, sorry.
I have other things to do today.
During the week of April 26, 2004 to May 2nd, 2004, Kaylin had a friend staying at the apartment for the duration of the week. And during this entire week, my room door was closed. I would come home at the end of the day. Things would be rearranged. I was accused of things I didn't do. I would get up in the morning, leave to go to my student teaching assignment, and I would come back at the end of the day, and Kaylin's guest would say to me, well, what the hell were you doing? Why were you slamming doors this morning? I wasn't slamming doors.
Okay, next. Move on.
Next. She had an underage drinking party on May 1st, 2004. During this underage drinking party, chairs belonging to me were broken. A fight occurred that I was told about by both Kaylin and Mindy.
Okay, so you weren't happy. When did you move out?
On or around June 14th, 2004.
When had you signed a new lease?
In the middle of March.
So March you signed the new lease, and when was the term of that lease?
The term of that lease was set to begin on August 15th, 2004.
And you moved out in June?
Correct.
Why didn't you get a new roommate?
Ms. Zemlica had left a note for me the last day she moved out saying she'd be back in August.
Can I see it, please?
And aside from that note, no.
Home for the summer, back on Sunday for the rest of my stuff, back for good in August. When did you write this note?
When I left in June.
Well, if you left in June, were you intending to come back?
At that point I was, because I had not yet talked to my lawyer.
You see, Miss Zemlica, if you were moving out for cause and you wrote her a note and say, I no longer consider it safe here, please try to get a new roommate in June or in May, because a lot of these things happened in May, I would say to the plaintiff, listen, you have an obligation to mitigate your damages. In June, the possibility exists for her to still get another roommate. But if she's holding off because you've assured her that you're coming back in August, that's unreasonable. You were fooling her, right? You're her father?
Yes, I am. Judge.
Sure. You were fooling her. You were saying, I don't know what to... You can move over. I don't know exactly what I'm going to do, but I want an opportunity to speak to my lawyer, and then I'll figure out what I'm going to do. Now, when did you finally tell her that you were not going to move back?
I sent notice.
When?
June 23rd, 2004. I have a copy of the letter right here.
Let me have it. Where's the notification that you sent to the plaintiff?
I did not send notification to the plaintiff.
Why not? June 23rd, you sent notification to the Capitol Center Apartments. Why didn't you send her notice?
I did not send her notification because things had deteriorated so rapidly and so far at that point that I did not feel safe talking to her anymore. I had received...
Nobody asked you to talk to her. What you have to do is send her a notice. And you never did.
I did not. However, my parents were in contact with her parents and did inform her mother that I would not be moving back in.
How do I know that? That's hearsay.
No, Judge, I talked to her mother. I'm Jennifer's father, and I did talk to her mother and said it's no longer capable of being resolved. Kaylin doesn't want to talk to Jennifer. Jennifer does not feel safe there. So there's nothing that can be done except to move out.
Your Honor, my hearsay was that he had talked to my 18-year-old brother, and that my mom actually talked to...
Just a second. They did the wrong thing. You may have done the wrong thing by having these people over that she didn't want over her home when she's not there. You understand that. But you have absolutely no right to first send her a letter indicating that you were coming back in August, despite the fact that there had been problems, so you were tricking her. Then you went to see a lawyer. Your lawyer gave you whatever advice the lawyer gave you. As a result of that, you did have the good sense to send a notice to the apartment complex. Did you get an answer from the apartment complex?
Yes, I did, Your Honor.
Let me see the answer.
They did not contact me in writing. They contacted me through a voicemail.
No. That's hearsay. Because if they were going to let you out of the lease so that she was no longer responsible under the terms of that lease, it would have been in writing. And you did not get that. Is that right?
That is correct.
Okay.
Judge Judy continues in a moment. Kaylin Zillmer says ex-roommate Jennifer Zemlicka owes for breaking their apartment lease. Jennifer says it wasn't a safe place to live.
Your Honor, I was also sent a letter by Kaylin Zillmer claiming that she was responsible for the lease and for the rent because she was still living there. And I received in July.
That would be my half of the rent.
Of course she's still responsible because she's still living there. That doesn't mean you're not responsible. You wouldn't be responsible if you did the right thing. You did the wrong thing.
I believed I needed to move out to protect my own personal safety.
I don't disagree with you. Not your own personal safety. It had become uncomfortable for you to live there. Put your hand down. It had become uncomfortable for you to live there, and you have an absolute right not to live someplace where you're uncomfortable. You don't have the right to trick her, which you did. You tricked her into thinking that you were coming back at a time when this is, I assume, a college town where people look for apartments up until the end of the school year. You led her to believe that you were, in fact, coming back in August. She did not seek another roommate. You notified the apartment complex of your intention not to come back, but you never notified her. You could have just as soon sent her a copy of the letter. Then you would have put her on notice. Then I would have said, now listen, you have the obligation to mitigate your damages starting in June. You may not be able to find a roommate right away. Maybe she's only liable for 6 months' rent or 3 months' rent until you find a roommate.
And Your Honor,
but you didn't do the right thing. You can't just walk out. Now, who's living in the apartment?
I am, Your Honor.
Who else?
Just me.
What efforts have you made since you were notified that she was not intending to come back to try to find another roommate?
I have been to different websites. I have left up flyers around campus. I have a website to roommates.com, so I have made efforts to cover her half of the rent.
Just a second. And what's the rent on the apartment?
It's $940 a month.
When were you notified that she was not going to move back to the apartment?
In August.
Are you telling me that you didn't know until August that she wasn't coming back? Is that what you're telling me?
That's right.
Okay. Where do you live?
I live, Kelly Zillmer. I live down the road from Kaylin.
Who do you live with?
I live with 4 other girls.
When did you sign your lease on that place?
Well, we signed the lease in December for the upcoming year starting in August. So our lease started August 15th and runs till August 14th next year.
And if you could find another roommate at your house, you could move in with your sister. Is that right?
Well, there's not many people looking for roommates anymore since college started.
Well, people come in January, do they not?
Yeah.
Sure they do. So we have September, October, November, December, January. That's 5 months, right? She's got to pay you for 5 months. You did not give her adequate notice. You gave her, as a matter of fact, no notice whatsoever of your intention to move. was only through a third party that she found out that you did not intend to come back. You cannot do that. She's obligated to pay for the rent, and she's the one who's suffering for it because you evidently found another place to live. You're paying nothing, and she's paying for both of you. That's unreasonable. You have a right to move out of the apartment if you feel unsafe. You also have an obligation to give her notice of your intention and not to trick her, which you did. You tricked her, and you can't do that. Judgment for the plaintiff in the amount of $2,350. That's all.
Parties are excused. You may step out.
And now the next case.
All parties in the matter of Bump versus Hansard, step forward, please.
Policeman Marcelo Bump is suing his neighbors, Jamie Hansard and his brother Nathan Hansard, for damaging his Mustang GT when they shot off fireworks on the 4th of July.
Mr. Bump, the two defendants are your neighbors.
Yes, ma'am.
And it is your claim that last July 4th, your two neighbors were setting off firecrackers. Some of the firecrackers landed on your car.
Yes, ma'am.
Causing damage to your car's paint.
Yes, ma'am.
And you want them to pay for the damage.
Yes, ma'am.
The two defendants acknowledged that they were setting off firecrackers.
Yes, ma'am.
But that there were a lot of people setting off fireworks. And there's no way to tell whether your fireworks were the ones that actually caused the damage.
Yes, ma'am.
How old are you?
30.
And you?
I'm 25.
Are you related to each other?
We're brothers.
Do you live together?
Yes.
Who else lives with you?
My 3 children.
Now tell me about the fireworks you were setting off.
We were shooting fireworks that...
What kind?
They're different names. Some Tommy guns.
Tommy guns.
Cherry bomb.
Cherry bomb.
Black Widow. Black Widow. 4th of July.
Just a minute. Black Widow.
4th of July.
So you had at least one of each of these things.
Several.
Where did you buy them?
North Carolina.
Where do you live?
Georgia.
You bought them in North Carolina. And where did you shoot them off?
In our parking lot.
In Georgia.
Yes, ma'am.
Why didn't you buy them in Georgia?
Because you can't buy them in Georgia.
Why not?
They're illegal.
So you just traveled a little bit and went to North Carolina and bought them there.
Yes, ma'am.
And despite the fact that the law precludes you from using them in Georgia, you used them.
Yes, ma'am.
And now you expect a court to be fair to you. Is that what you're telling me?
I admit I broke the law. But damaging his vehicle is a different story.
Just a minute. No. You're not saying that you didn't damage his vehicle. What you're saying, I believe, is there were a lot of people that were violating the law, and there's no way to tell whether it was my Tommy guns, cherry bombs, Black Widows, 4th of Julys, etc., that actually caused the damage. Because there were a lot of people.
There were a lot of people shooting fireworks, so...
There's no way to tell. Is
There's
that
no
right?
way to tell that it was ours, no.
Correct. That's your defense.
Yes, ma'am. We don't believe that his vehicle was damaged by fireworks, period.
Fine. That's a different story. If there was no damage to his car, then you wouldn't be responsible. But let me tell you something. When you break the law, and you broke the law in front of your 3 children, which is even more vile, because then what you're teaching your children is there are certain laws that are meant to be broken. There are certain laws you can pick and choose what laws you want to obey. That's the message you're sending to your children. It's ridiculous for the state of Georgia, where we live, not to have fireworks. So you don't have to obey that law. If you want to shoot off fireworks, you can. Is that the kind of message you want to give to your kids?
Some may portray it that way, yes.
What do you mean some might portray it that way? That's exactly what you did. You knew it was against the law to purchase fireworks. You knew it was against the law to shoot off fireworks in the state where you live. Despite that, you, who are the custodial parent for 3 children, who was supposed to teach them the difference between right and wrong, you've taught them that they can selectively choose what laws they want to adhere to and what laws they can break. Because they say, listen, my father breaks the law. My father does things that the state says he can't do. You're teaching your children that breaking the law is okay, and that's the wrong thing. And then you can't come to court and say to me, or to any judge, he has to be able to establish beyond a reasonable doubt that it was my fireworks that damaged his car. No, he doesn't. He just has to be able to prove that you, against the law, were shooting off fireworks in the proximity of his car that could have damaged his car, at least in my world. The issue is not really whether you are responsible if there was damage to this car. You're responsible. The issue is, was there any damage? That's what you say. There was no damage. So, now, we've established one thing. Now you can show me the damage.
Ma'am, I have some digital pictures taken of the vehicle.
You have an estimate to fix it?
Yes, ma'am.
Can I say something?
Sure.
I have pictures of the same vehicle and the same area that show no damage, and they were taken 3 days ago.
Let me see. Let me see both.
I also took several shots of other parts of the car to show that weren't any damage to it either. Because I believe the estimate that he had stated that front fenders, hood, several parts.
Oh, I see the damage, sir. I don't know where your eyes are. I see it. It's just that your pictures are farther away than his are. His are close by. I see the damage, the exact same place where it shows here, right above this little thing. I see it. You should look a little bit closer or get your eyes checked.
Okay.
Anything else anybody wants to say to me?
I have an estimate that states what he was claiming. His estimate claims as far as clear coat on the damage of the car can't be damaged by fireworks unless they're shot completely, right on the paint. Something that hit it or landed on it said it can't be damaged. I don't know. That's just a statement that a body shop says.
You have a witness here for me to read?
No, ma'am.
You don't have?
No.
Yes, we do have a witness.
You have a witness?
I have a witness to state what we did, but not as far as
I know
the
what
body
you
shop.
did. You told me what you did. You illegally purchased fireworks and you illegally shot them off. What do I need a witness? Is that what they did?
Yes, ma'am.
Perfect. Your witness corroborates that. Judgment for the plaintiff, the amount of $923.